Welcome to our webinar, Returning to the Workplace, Top 10 Employment Law Issues Facing Employers. We're going to be going for about an hour today, while I assume everyone is having a nice lunch listening to us. Before we get started, I've got some webinar logistics to review. So, aside from the presenters, all of the participants on this Zoom are muted. So if you would like to ask questions, and we encourage you to ask questions, please do so by submitting them in the Q&A box using Zoom. The other thing that we have to tell everyone before we get started is that this webinar is being recorded and it's going to be distributed after the webinar, along with copies of the slides that you're looking at. Mark, can we have the next slide, please? So let me introduce myself and the rest of the team on the line with us. My name is Jon Landesman. I am a partner and co-chair of the Labor and Employment Group at Cohen, Seglius, Pallas, Greenhall, and Furman. Along with me today are two associates on our team, Marc Cytryn and Hope Steidle Kildea. And we all specialize in employment litigation and in particular in helping our employer clients deal with and counseling issues to ensure compliance with labor and employment issues and making decisions, whether that's termination decisions or otherwise. We put this seminar together today because we want to help our clients with some recurring issues that we're seeing a lot of employers deal with related to returning to work following the COVID-19 pandemic. And so we hope that this top 10 list that we've put together for you will be informative and hopefully entertaining as well. And I really do encourage people to feel free to ask questions. We'll try to address them as we move through the slides today. Next slide, please, Mark. So let's dive right into it. Number 10 on our list. Can I have a mandatory vaccination policy? The answer is yes. Employers can have a mandatory vaccination policy. There have been a handful of lawsuits that have challenged these policies, one in Los Angeles, one in New Mexico, more recent one down in Durham, North Carolina. But the consensus among commentators and employment lawyers looking at these lawsuits that challenge the mandatory vaccination policies is that they're generally without merit and that the law does specifically allow an employer to have these mandatory policies. But if you do want to have a mandatory policy, you need to consider a few things. The first is exceptions. You need to make exceptions for certain employees. The first exception is for individuals who cannot or will not get the vaccine because of their religious beliefs. And when you're talking about religious beliefs in this context, it's a pretty low standard in terms of, the employer can't really get into analyzing the employee's alleged religious beliefs and trying to question whether or not they really prohibit the vaccine. If an employee comes forward and says they have a religious objection to vaccines, it's pretty difficult to get around that. Second, an employer needs to make exceptions for individuals that can't get the vaccine because of medical conditions, they're disabled, or if they're pregnant, or if they're nursing mothers. The other thing to consider is state law, and there's pending legislation in other states regarding this issue. 11 state legislatures have passed rules and laws that say that mandatory vaccine policies are either unlawful or that an employer can't punish or take an adverse employment action against an employee because they refuse to get the vaccine. So that's in 11 states. 9 more, or I believe it's 8 more states for a total of 19 states have similar executive orders along those lines. So there are a number of states where the answer is no or a modified no on whether you can have the mandatory vaccination policy. Pennsylvania, New Jersey, are not in those states, although interestingly, in the Pennsylvania House and Senate, there are bills pending that would do just that. Although, again, most commentators and lawyers who are following this, and we're following it pretty carefully, believe that those 2 bills in Pennsylvania are not going to really go anywhere. They're not going to become law. What about instead of just having a mandatory vaccination policy, what about an incentive or a bonus program? So can I say to an employee, I'm going to give you some additional PTO time, or I'm going to give you a small bonus if you get the vaccine? The EEOC issued some guidance on this and sort of reversed course. What the EEOC's latest rule is basically two different rules depending on the scenario. If the employee goes out and gets the vaccine from a completely independent source, like at a pharmacy or some other healthcare provider, then the employer can offer just about any type of incentive it wants and doesn't have to worry about the value of the incentive. If the employer sets up a clinic and has like its agent provide the vaccine, then there's a limit, and the EEOC says that the bonus or incentive that's provided to the employee can't be so great that it would be deemed coercive. So in other words, in that scenario, the latter scenario, providing something like a water bottle or a t-shirt is really the maximum incentive or bonus that we'd want to provide to the employee. Otherwise, if they're going out and they're getting it at the local CVS or something like that, there's no limits on the incentive or bonus that we can provide under the new rules. What about for union shops? So if you have a collective bargaining agreement with a union, do you need to bargain with the union before you implement a mandatory vaccination policy? And the answer is that vaccine policies like this would be considered a mandatory subject of collective bargaining. And so in most cases, the employer would have to sit down with the union and negotiate over the policy, and couldn't implement a policy unless the union agrees to it. I think the only exception there, and if you find yourself in this circumstance, is you'd want to look at your current collective bargaining agreement. And most collective bargaining agreements have a management rights clause that reserves for the employer the right to implement certain rules. Sometimes it says to implement rules or policies that relate to health and safety. And so if you had that in your current collective bargaining agreement, presumably you could use a provision like that in a management rights clause to squeeze through and implement the policy without bargaining. But again, that would be on a case-by-case basis. Mark, let's take a look at the next slide. So related to vaccination policies, vaccination cards. Let's say, and let's look at the example, even if an employer does not have a mandatory vaccination policy, can it still ask to see the vaccination card? The answer is yes, you do have a right to ask employees for a copy of their vaccination card. The EEOC actually has come out and answered the question that many employers had asked, which is, well, I always thought that the ADA and the FMLA and all these laws that are out there prohibit me from making medical inquiries and asking employees for information. Well, the EEOC has said that asking for a vaccine card doesn't fall within those rules, and it's okay to ask. But when you're asking for that information, you want to be very careful not to fall into the trap of asking for additional information. So if someone doesn't have a vaccination card, they haven't gotten vaccinated, you don't want to start asking them about the reasons why they didn't get vaccinated. If someone did get vaccinated, and even though this sort of seems like just a benign question that might arise in passing, but asking someone how they reacted to the vaccination. Did you have a lot of effects? Did you feel sick afterwards? Those sorts of questions can get an employee talking and start revealing information about their medical conditions and disabilities that we just don't want to know as employers because it gets us in trouble. So the best practice, only ask to see the vaccine card, no more than that, and keep that information on a strictly need-to-know basis. So that means there can be a point person in human resources who collects that information. They have it, and it shouldn't be shared generally or broadly with all the managers and supervisors in the plant. If you have someone who's uncooperative, they refuse to tell you whether or not they have it, it's not the time to terminate or discipline that person. Instead, we would just treat that person as someone who's not vaccinated. Next slide, please. So now that we've talked about vaccinations, let's move on to the next item, number 9 on our top 10 list. We're counting down here.
Actually, John, before we move on, we just got a great question. What can a contractor do if they have union employees at a job site where the general contractor or the owner has mandated vaccinations?
So if a contractor has union employees and we don't have an agreement with the union, but the customer is saying, I'm not letting you on this site unless your employees are vaccinated, can we require vaccinations of all people then? The answer is no. I mean, we can't mandate vaccinations just based on a customer preference without going through the union. So as a practical matter, the first thing that the employer should do is contact the employer association that negotiated the agreement, determine whether or not there's been an agreement, because a lot of the trades have reached agreement on vaccinations. And then barring that, the next thing to do would be to work with the union hall and try to see if we can work out either an agreement or filter through so that we're only getting people who can produce cards and deploying them to that particular site. Okay, and so I welcome questions. Let's keep it going. That was a good one, Hope. Number 9, can I require non-vaccinated employees to wear a mask? So just taking a step back, we know now that in Philadelphia and in New Jersey, Pennsylvania, the masking requirements have been scaled back or eliminated. And now the local and state laws are generally saying that people, even indoors, outdoors, we don't need to wear a mask. They say that people who are non-vaccinated, for example, in Philadelphia, I just looked at the most recent guidance, the language is it's strongly recommended that non-vaccinated people continue to wear a mask indoors. Can an employer go beyond that though? Even though the CDC or the state or local requirements say that it's only recommended, it's not mandatory, can an employer mandate it? And the answer to that question is yes, an employer can require that unvaccinated employees wear a mask. If an employer wanted to, an employer gets to set the rules in its own workforce. An employer can require that everybody wears a mask if we wanted to go that far. The other thing, of course, to think about when you're talking about masking is industry-specific rules. For example, the OSHA guidance, again, it's not mandatory, but they're still recommending masks for unvaccinated workers within 6 feet of other workers. Let's move on to the next slide, please, Mark. So what are some of the other additional changes that we're seeing as we follow these things? It seems to happen, it's almost a daily or weekly basis that we see new laws or tweaks to the laws. Well, we're seeing executive orders like New Jersey Executive Order number 244, that's lifting the previous requirements. So Executive Order 244 essentially says the state of emergency that was declared and all of those requirements that went along with it, the daily screenings, all of these things are now revoked, and the state of emergency has been lifted in New Jersey. Same thing in Pennsylvania. And then on the other side of the country, and we don't know if this is going to be a trend that we see because of the Delta variant or because of other issues that no one can really predict what's going to happen. Are we going to see mask mandates being reintroduced on a broad scale? And that remains to be seen. Of course, we'll monitor that very closely. So with that, Mark, why don't you pick it up from there?
Thanks, John. So number 8 on our top 10 list today is, how do I handle employees who want to continue working from home? And that is a key issue that many employers are going to face now, especially with state and local guidance being lifted and places reopening. Now, as a general proposition, employers can require their employees to physically report to the workplace. However, it is still important to keep in mind that certain exceptions could apply and should be evaluated on a case-by-case basis. So earlier on, John mentioned that there could be some exceptions to a mandatory vaccination rule. The same kind of logic applies here. For instance, if you have an employee with a known medical condition that's disclosed to you as an employer, and that medical condition makes it unsafe for the employee to return to work due to potential exposure to COVID or for some other medical reasons, that's a situation that the employer would have to evaluate and determine whether or not there's an accommodation that can be provided. The accommodation that immediately comes to mind is, can I allow this employee to continue working from home instead of physically coming into the office? And of course, if we're going to evaluate cases like this independently, we want to make sure that we're applying the same standards to everyone. So for any employee who says to you as an employer, I need to continue working from home, or I have a medical condition that prohibits me from coming into the workplace, you want to look at the objective criteria at issue. And that objective criteria includes the specific position, the specific job duties, and the performance standards or performance for the employee at issue. And so, for instance, if an employee is a construction worker and is in the field doing work with his or her hands on a daily basis, it's not going to be possible in all likelihood for the employer to allow that employee to work from home. They need to come into the physical workplace or go out to job sites, and their role is to work with their hands. So in that situation, it's going to be unlikely that employer can accommodate the employee who doesn't want to return. On the other hand, if you have an office employee who generally works, let's say in your accounting department or in your back office doing administrative functions, if that employee has a medical condition and is able to provide you with documentation from his or her treating physician, that situation is a little more complicated because it could be that you are able to let that specific employee perform their job duties at home. So really, it does require a case-by-case analysis. And then going along with that, along with the general proposition that employers can require employees to come back to work, it's important to keep in mind that this solely the fear of returning to the office because you may contract COVID-19, that in and of itself is not a sufficient legal reason for an employee to continue working from home or refuse to return. So there needs to be a legitimate exception, going back to an example where there's a medical condition, or perhaps the employee is serving as the caretaker for another relative that's living with them, something of that nature, as opposed to just a general fear of returning to work. So along with the scenario of employees continuing to work from home, if there are exceptions that arise, it's important to also keep in mind that there are some other considerations out there. One of those key considerations relates to wage and hour issues. So of course, employers have typically both exempt and non-exempt employees working for them, and the exempt employees, they get paid on a salary basis, but the non-exempt employees are generally tracking their hours that they work each day and reporting those hours to the company. when you have employees who are working from home, let's, for example, say an administrative assistant or someone else who's generally tracking their hours if they're in the workplace. A key issue is making sure that even though the employees are working at home, they're still reporting their hours each day and doing so accurately. So if your company has time cards or an electronic punch in, punch out system, that same system or a variation of that system still needs to be used for the employees that are working from home and are non-exempt. The other issue that goes along with non-exempt employees working from home is, generally speaking, when somebody's working from home, it's a bit easier for them to deviate perhaps from their normal schedule and say to themselves, well, I'll do some work after hours or maybe after I clocked out because I wasn't as productive today as I could have been. You need to make sure that employees who are non-exempt are not working off the clock like that, because it could give rise to issues related to overtime. And in order to mitigate the risk for that, it's good to have, and it's recommended to have, a strong policy that prohibits employees who are non-exempt from performing work off the clock, quote unquote. And in addition to these wage and hour issues, employees who continue to work at home, there are also concerns related to protecting your company's equipment and safeguarding, for instance, customer information or the company's financial information, especially if somebody is working with that information, perhaps as a accounts payable clerk, as someone in your financial department, and continues working from home. And so in that regard, some key points to keep in mind are, if somebody is dealing with confidential customer information or the company's financial information, tax returns, et cetera, loss and earning statements, that information and those documents should really not be located on the employee's personal desktop or transmitted with the employee's personal email. You should have a policy and make sure that your employees understand that if they're handling that type of information that's sensitive, it needs to be handled through the company systems and through their company assigned email to make sure it's safeguarded and not just floating out there on a personal desktop or personal email system that could be potentially hacked by an outside party. And keeping all that in mind, with the idea that even after the COVID pandemic is beginning to wind down, there are still many employees and employers who are continuing work from home policies into the future. And for that reason, it's a very good idea to have a strong written telework policy, either in your handbook or as a standalone policy, to spell out clearly what the expectations are, what the rules are for working from home. For instance, you want to specify, if you have non-exempt employees, that they still need to accurately track and report their hours each week. And you also want to specify that the performance standards remain the same. Even though employees are working from home, they're expected to still generate the same productivity and perform their jobs in a satisfactory manner. In these types of telework policies, it can also spell out that if an employee is granted the privilege of continuing to work from home and fails to satisfactorily perform their job duties, that privilege can be revoked. It's by no means a guarantee that they can work from home forever. So, going along with the concerns about employees working from home, a very common issue and a concern to employers is, how do I track employee productivity if people are working from home? And so it's true that there is software out there and there are ways for employers to monitor their employees' productivity from home. For instance, an employer can see how many keystrokes someone enters on their computer in a given day, how many times the employee's screen idles for more than a certain amount of time, which would suggest that they've left their workstation. And there are also employers out there who may be considering even having video surveillance on an employee's workstation working at home. So while all those ideas may sound good at first to an employer, the key issue is that if you're going to have surveillance or tracking of an employee in their personal home to see how productive they are, you need to have consent from the employee. So for instance, if you're going to monitor, let's say, install video surveillance or or capture an employee's personal desktop while they're working, you need to make sure you have written consent from the employee because they are working from home. And you also need to be very careful that you're not capturing other individuals who may live in the employee's home, because that could give rise to privacy concerns. So while tracking employees from home is possible, consent from the employee is the key issue. And then in addition to that, with respect to monitoring, it's generally okay to look at an employee's company emails and monitor what they are and what they are not doing, but you cannot monitor an employee's personal messages or emails, even if they happen to be available to the employer to see. And with that, I'm going to hand off to Hope, who's going to speak to you about issues related to workers' compensation and also medical marijuana.
Hello. So topic number 7, can an employee with COVID-19 file a workers' compensation claim? So this is an issue that's dictated largely by state law. Each state's workers' compensation statute will decide what is and isn't compensable. Generally, state laws are allow for compensation resulting from a work-related injury or an occupational disease. An occupational disease has to be contracted while at work or in the performance of work. And generally, states require the exposure to the disease to be caused by some kind of characteristic or condition that's particular to the industry that the worker's in, or their trade, or their place of business. Some states even exclude diseases that are called ordinary life diseases, like the flu or the common cold, that we expect to be exposed to just by going out in the world and aren't really particular to an occupation. But in that way, it can be kind of industry specific. It's really on the employee, it's the employee's burden to show that they contracted COVID while at work or while working. And this is really the bar that we're seeing to a lot of workers' compensation claims, because even if the contraction is considered compensable, the employee still needs to show that COVID qualifies as an occupational disease, that they contracted it at work, which can be difficult. Some states have tried to address this issue by passing laws that create a presumption in favor of certain employees. And these are industry specific. So these largely target the medical industry, public safety employees. At least one state has pending legislation on school workers, educators. During states of emergency, some states have either had laws that have expired or considering laws that will also cover essential workers during a state of emergency. And what these laws basically do is take that burden off the employee and create a presumption that workers in this industry who contracted COVID contracted it while at work. So PA, for example, has indicated that contracting COVID while at work would be covered by workers' comp. But again, the issue is really whether an employee can show either they're in one of those covered industries or that they contracted COVID while at work. Okay. Okay, there we go. Okay, sorry, we're getting questions coming in. Issue number 6, can I still include marijuana in our drug testing policy? So the answer is generally yes, but with limitations. And again, this is state specific. And a big part of that is the state laws coming out that are legalizing recreational marijuana use and the impacts that has on employers' ability to enforce their drug and alcohol policies. So the protections that are in a lot of these legalization statutes target protecting off-duty recreational marijuana use. They don't prohibit an employer from enforcing their drug-free work policies. So these protections don't allow employees to use recreational marijuana while at work or to be under the influence of recreational marijuana while at work. but they do protect employees who choose to use recreational marijuana in their own time. And the effect that has on employers comes up with employee testing. A lot of times these statutes restrict when an employer can test employees, what they can do with the results of these tests. So the area where we're really seeing a decrease because of these protections is pre-employment drug testing. That's when an employer requires an applicant or a potential employee to pass a drug test before starting. And again, this is a state-specific issue. We generally recommend we wait until after a conditional offer has been extended to an applicant before requesting or requiring a drug test. Post-accident and probable cause testing has really continued and remains largely unaffected by these statutes. Post-accident is when an employer has a standard policy that after any kind of workplace accident, usually one resulting in damage to property or injury, that those involved be subject to testing. And then probable cause testing, sometimes called reasonable, I believe New Jersey calls it reasonable suspicion testing, is when the employer has reason to believe that someone is under the influence of drugs or using drugs in the workplace and can then test the employee. In terms of disciplinary policies for positive results, this will again depend on state law and also the regulations that the industry is covered by, particularly employers who are subject to Department of Transportation regulations will have to make sure that their disciplinary policies comply. Zero tolerance policies can be difficult to enforce in states with more liberal marijuana policies and more protections for employees. Progressive discipline can give employers a little more flexibility to make sure that they're compliant with their state's laws. Last chance arrangements are also an option where if an employee tests positive, the employer can enter into an agreement with the employee, giving them one more chance that if they test positive again, they'll be terminated. And the agreement can be conditioned on the employee successfully completing some kind of rehabilitation program and agreeing to be subject to a drug test when they come back and test negative. Okay, we can do the next slide. Okay, so medical marijuana use presents a separate issue. There are some additional protections for marijuana users under state laws. So like most states, New Jersey and PA require or allow employers to discipline employees for on-the-job medical marijuana use. Just like recreational marijuana use, employers aren't generally required to accommodate medical marijuana use or being under the influence of medical marijuana while at work. And Pennsylvania, New Jersey, neither of those require an employer to allow employees to use, possess, or transport marijuana in the workplace or during work hours. Okay. So earlier this year, New Jersey passed a new legalization law that is one of the most liberal policies we've seen. A lot of medical marijuana laws have carve-outs for what's called safety-sensitive industries and positions. So employees who are in some kind of position where if they were to be under the influence of marijuana or any drug, they could have a negative effect on the safety or the health of other employees or the general public. New Jersey's law does not contain this provision. It's seen a lot of criticism for that reason. There's already pending legislation to address that, but that has not been passed yet. So at the time, we're proceeding with some caution, and it's also possible that that issue will be addressed with regulations interpreting the law, but we're still waiting to see. The law does have a carve out for contractors who are subject to a federal contract, and that their funding would be dependent on them complying with federal regulations or laws that conflict with New Jersey's recreational marijuana law. So if some kind of funding for a contract is on the line, then contractors are allowed to maintain their whatever policies are required by the federal law and regulations. Philadelphia has recently has implemented an ordinance that will ban the screening of marijuana in new employees effective January 1st of next year. Exceptions are for employees that are required to have a commercial driver's license, or those whose, like the safety sensitive position, those whose positions could have an impact on the health and safety of others.
Thanks, Hope. So I'm going to take the mic back here, and number 5 on our list of top 10 issues is, can I classify returned workers as 1099 contractors? And this issue is especially important to those in the construction industry. As you're likely aware, in Pennsylvania in particular, we have to address the Construction Workplace Misclassification Act, or Act 72. And that law essentially says that if employees, or workers, I should say, are in the field doing manual labor with their hands for a construction industry employer, they cannot be classified as 1099 contractors. Instead, they have to be classified as employees, and they have to be subject to payroll taxes being withheld, along with being offered any benefits that you may give to other employees. And so the issue is so prevalent because under Act 72 in Pennsylvania, it's not just that there could be potential civil ramifications for misclassifying a construction worker or a field worker as a 1099 contractor, but in fact, there could also be potential criminal liability. And previously, that wasn't such a huge issue, but under Josh Shapiro's current administration as the Attorney General, there has been an uptick in efforts to enforce criminal violations of Act 72. And for example, earlier this year, there was a Delaware County, Pennsylvania drywall contractor who was charged with criminal violations along with several other individuals for misclassifying workers. And that served as a really powerful example of how serious this mass misclassification issue is. And so if you are a construction industry employer in Pennsylvania, you need to be mindful of this requirement for your field workers and your manual laborers to be classified as employees. And this doesn't just relate to construction industry employers, however. It's also important to keep in mind that in general, in Pennsylvania, New Jersey, and really all over the country, there's an uptick in departments of labor and government agencies enforcing misclassification issues and investigating them. For instance, if you have an office employee, if you're not a construction industry employer and you have an office employee who's working under your supervision for the vast majority of time in your office and doing work for you, you need to be mindful of the fact that that individual, just like a construction worker in the field, should be classified as an employee. And the real test for whether or not someone should be classified as an employee is whether or not the employer is exerting control over them. If you're supervising and controlling the manner in which someone performs their job duties on a day-to-day basis, you really need to make sure that you carefully analyze that person and ensure that they're being properly classified. Going along with that issue, Act 72 in itself has some expressed requirements for where someone can be classified as an independent contractor and paid via 1099. You can see that the first criteria is there has to be a written contract. So if you have workers who are performing manual labor for you in the field and they don't have a written contract, you can forget everything else. They need to be classified as an employee. Number 2, going to what I was saying before, the worker needs to be free from control or direction over the way in which they perform their job duties. So if you have someone who's working for you and is taking orders from a supervisor or a foreman, whatever it may be, that's going to be an issue if you're classifying them as a 1099 independent contractor. They should really be classified as an employee. Number three is a really big issue, and it's important to keep in mind that generally speaking, a worker cannot be classified as an independent contractor unless that worker actually has their own independent business and is engaged in that business outside of the work that they do for you. So if you have just one person who doesn't have any other job or doesn't have their own business or an entity of their own that you're contracting with, and that person is performing work for you, in all likelihood, they need to be classified as an employee, not a 1099 independent contractor. And these types of requirements that you see, the criteria listed here, 1 through 3 for Act 72, they're generally the same criteria that apply to other instances outside of the construction industry as well. And it sets forth the type of tests that a Department of Labor would use to determine if someone is misclassified. To that point, later on, Jon is also going to speak to you a bit about the PRO Act and how that could potentially impact misclassification issues. So the next topic we have here on our top 10 list is, what is the status of the FFCRA? And the FFCRA is the Families First Coronavirus Response Act, probably everybody's favorite topic during most of 2020, and also the topic that many employers, if not most, had questions about. So as you likely know, if you're an employer that had less than 500 employees, from April 1st, 2020 through the end of 2020, you were required to provide employees with paid leave for certain qualifying reasons related to COVID-19. Now, those requirements, the requirement for an employer to provide paid leave under the FFCRA, those ended on December 31st, 2020. So employers are not required to give this paid leave anymore. At the same time, however, under the recent stimulus package, the American Rescue Plan, employers do have the option of continuing to provide paid leave under the FFCRA for the same, and we'll talk about some additional qualifying reasons related to COVID-19. If you do choose as an employer to continue voluntarily providing that paid leave, there are a few things that are important to keep in mind. Number one, you cannot discriminate against employees based upon the reason that they may request leave. For instance, if you're going to provide employees with this paid leave, if one employee wants to take paid leave because he or she is testing positive for COVID-19 and needs time off for work, you cannot grant that person paid leave under the FFCRA, and on the other hand, deny someone who would otherwise qualify because they have childcare related issues the same paid leave. So you have to apply the qualifying reasons uniformly across the board. In addition to that, the same dollar for dollar tax credits still apply. So if you continue to voluntarily provide paid leave under the FFCRA, when you file your quarterly 941 returns, you still would have the ability to apply for tax credits from the federal government to reimburse you for fronting the cost of this leave. In addition to that, it's important to note that if you voluntarily provide the leave, any FFCRA leave that was taken before April 1st, 2021, you can forget about that. It does not count against an employee's leave entitlement going forward from April 1st, 2021 through September of 2021. There are also a few, as I referenced earlier, new qualifying reasons for leave, most of which relate to the fact that the COVID-19 vaccine has become so prevalent and employees are generally going to get that perhaps during working hours. So the first qualifying reason for leave that's been added under the American Rescue Plan is that if an employee is unable to work because they're going to get the COVID vaccine, they can take paid leave under the FFCRA, assuming that you continue to offer it. Similar to that, if an employee gets the COVID-19 vaccine and experiences symptoms related to a reaction, they can take paid leave under the FFCRA. And lastly, if an employee is waiting or seeking a medical diagnosis of a potential COVID-19 positive result, if the employer makes them go get that test or they're exposed to COVID-19 in the workplace, they can also take leave. So if you find yourself in a situation that coming back from this COVID-19 pandemic and reopening your business, that it's still just difficult for you to get by and you may need to downsize, that goes to our third topic, our number 3 on the top 10 list, which is how can I downsize and avoid potential claims? So anytime you're going to lay off employees, reduce their hours, reduce their pay for business reasons, there's always a concern that an employee could try to bring a claim against you. So if you're conducting, for instance, a layoff because you need to cut a certain number of employees in order to continue operating, you need to make sure that you apply objective criteria when selecting who and who will not be laid off. So for instance, you can look at a certain location of your business, you can look at certain positions, job duties, seniority, etc. But what you absolutely don't want to do is have a layoff that is focused or targeted on a certain group of individuals. For instance, as minorities in particular, or people above 40 years old. You need to be cognizant that you want to apply objective criteria and not give the appearance that the layoff was conducted for a quote unquote discriminatory reason. In addition to that, a few additional issues with respect to potential downsizing. Pennsylvania last year passed a law that requires employees conducting layoffs during the COVID-19 pandemic and going forward to provide employees with notice of their rights to apply for unemployment compensation benefits. And there's a form that you can get on the Department of Labor and Industry's website that satisfies that notice requirement. In addition to that, under the American Rescue Plan, there are COBRA premium assistance subsidies. In general, if an employee is laid off or involuntarily terminated for a reason other than gross misconduct, the employer is required to, and I should also say, unless the employee quits, the employer is generally required to cover the premium costs of the employee's COBRA coverage through September of 2021. Now, that cost is also, like with the FFCRA, reimbursed through tax credits. So you may front the cost, but ultimately you'll get it back. And then the last piece with respect to pay changes, if they're necessary, you need to make sure that there are no retroactive changes. So if it becomes necessary to reduce an employee's pay, you should provide that employee with written notice that their pay will be modified or decreased on a certain date going forward, but nothing that goes backwards in time, because that could give rise to some wage and hour issues or potential claims. And with that, I'll hand the ball off to Jon, who's going to give you number 2 on our top 10 list.
Number 2 is the Protecting the Right to Organize Act, the PRO Act, which I'm imagining many people who are listening in today have heard about and maybe not know exactly what it is. Big picture, the PRO Act is not yet law. It's a proposed piece of legislation bouncing around in Congress at the federal level. And it's designed to really change the labor laws dramatically in a way that hasn't been done for more than 50 years to make it easier for unions to organize, and the result being that a much greater percentage of the workforce would be unionized. That's what this legislation is designed to do. So let's talk about specifically what the legislation would do if it's passed. And again, it's pending. There's bills and versions of it. We don't know exactly what it's going to look like, but these are some of the things that we've seen in versions of the bill that that have been going around. And we should know also that the likelihood of something passing is very, very high, because the Biden administration has said that this is a very high priority for them. So this is definitely on the horizon in the near future. So with respect to union organizing, we say that we're going to see the return of ambush elections. What is an ambush election? Well, typically when a union goes to the labor board and they say, labor board, we want you to go out and conduct an election so that the employees at a particular company can vote yes or no for a union, there's a certain number of days between the date that they file that petition for an election and the date that the election happens. Right now, under the law, it's 42 days is sort of the standard amount of time. The PRO Act would shorten that amount of time, maybe to 21 days or something in that period. It could cut it in half. And so the result being that when you get the petition, there's an election just 3 weeks later. As an employer, you don't have time to respond. You don't have time to campaign and get your word or your message out to your people about whether they should vote yes or no. The next thing that the PRO Act would do, and this is even more dramatic, is possibly replace secret ballot elections. So right now, as I just described, a union files a petition for an election. An election is scheduled. The people go into a little voting booth and they have a secret ballot election where they vote yes or no. What would that be replaced with? With a card check election. So essentially, the union business agent goes around and they can go to the people's homes, knock, knock, knock. Who's there? It's the business agent. Gives the person a card. They sign the authorization card that says, yeah, I want the union to represent me. And if the union gets a majority of those cards, then the labor board doesn't even conduct an election. They say that the union essentially won the election just by collecting enough cards. That would make it dramatically easier for the union to win these elections. Right now, the unions win about half of all elections. We'd see that number skyrocket locally and on a nationwide basis. The PRO Act would also impose limits on the messaging and what the employer can say and when they can say it during their campaign. The PRO Act would impose interest arbitration in some situations. So what does that mean? What's interest arbitration? Well, let's say the union files a petition for an election. There's an election and the union wins. What does that mean when the union wins the election? Does it mean that the employer is automatically bound by a collective bargaining agreement, that they have to start paying different wages? No, that's not what it means at all. Under labor law as it's existed forever, if you lose an election, all that it means is that you have to recognize the union as the representative of the group of employees in the bargaining unit, and you have to sit down with the union and attempt to negotiate in good faith a collective bargaining agreement. And so, the union can ask for whatever it wants. It can ask for $5 an hour more. It can ask for all sorts of health insurance. And at the table, at the bargaining table, the employer can say yes or no. And if there's no agreement and there's an impasse in those negotiations, what's the union's weapon? What's their ultimate weapon that they can employ if there's an impasse and the employer says, no, we're not going to agree? The ultimate weapon is for the union to tell the people, okay, the employer's being unreasonable, they won't agree, let's go out on a strike and make them agree. And then the people have a decision. They can either follow the union, go on strike, or they can tell the union, no, we're not going on strike, in which case the union is essentially broken and they usually disclaim and go off into the night. We never see them again. In this case, if the PRO Act becomes law, it would change that whole scenario. And if the union and the company are unable to reach an agreement at the table on that first collective bargaining agreement, the labor board goes ahead and appoints an arbitrator to come in, listen to both sides and their proposals, and then say, you know what, after hearing what both sides say, here's your new collective bargaining agreement. We're imposing it on your business and you have to follow it. These are your new wage rates. So it's a third party that actually decides it. It's a totally different scheme than what currently exists under the law. The PRO Act would also resurrect something called the Persuader Rule. Persuaders are consultants who speak with companies and help them get out a message in terms of union avoidance or what the company's position is with respect to unions. The PRO Act would change those rules and specifically the definition of who is a persuader to make it very, very broad so that it would include attorneys. So most attorneys don't want to be considered persuaders because if you're a persuader, there's all sorts of disclosures that have to be made about who your clients are and how much they've paid you and when the services were rendered. So resurrecting the Persuader Rule, or the broadening of the Persuader Rule, would have a real impact on an employer's ability to engage with a labor lawyer if it's going through an organizing campaign. Let's take a look at the next slide, please. Some additional changes to the National Labor Relations Act, again, that would be imposed by the PRO Act. There would be new rules about secondary boycotts. What's a secondary boycott? It deals with picketing, and if a union has a problem with an employer, where could it picket? When can it picket? Can it picket the employer's customers? Can it go off site? All sorts of Am I back, guys? I'm sorry. I think I had a little computer glitch. You can hear me? Good. Okay, I'm sorry about that. So there are going to be new rules as far as picketing. The PRO Act would also change the rules so that someone who's an organizer could use an employer's email system. The PRO Act would take an ordinary administrative charge that had to be filed at the National Labor Relations Board and turn that into literally a federal case, a federal lawsuit, and it could increase the damages and the fines in these sorts of cases. So the PRO Act, again, it's a very, very pro-union piece of pending legislation that would have a widespread impact on just about every business. Let's take a look at the next slide, please, Mark. The PRO Act would also affect the issue that Mark was speaking about earlier, which regards the misclassification of employees as independent contractors. The PRO Act would essentially require that under federal law, at least, the ABC test would be utilized. And without boring you with all of the nitty-gritty details, the ABC test is much more anti-business and really makes it so that classifying someone as an independent contractor is really difficult, and it's the employer's burden to prove that they're a contractor, not by a preponderance of the evidence, which is usually what is employed in civil cases. But as you see here with the second bullet point, they'd have to utilize clear and convincing evidence. So for those of you who aren't lawyers, a preponderance of the evidence in a civil case, what does that mean? It means that I have to show more than 50% that I'm right. That's what a preponderance of the evidence means. In a criminal case, you probably hear beyond reasonable doubt. That means like 99% certain that the prosecutor is right. Clear and convincing evidence, it's somewhere in between. It's like 75% that you're right. And again, those numbers, it's not exact and mathematical, but that's sort of the gist of it here. So they're trying to make it harder for the employer to prove that someone truly is a 1099 or an independent contractor. Let's take a look at our number one issue. Our number one issue, again, it's a piece of proposed legislation or something coming down the road. Has the federal government banned non-compete agreements? I've had that question asked to me by a number of my clients. Earlier this month, on July 9, 2021, President Biden signed an executive order. It had a long list of about 70 different items in it. Buried within that list was President Biden's direction to the FTC of all agencies, the Fair Trade Commission, to issue a new rule that limits the use of non-compete agreements on a nationwide basis. So will the FTC issue a rule that's going to altogether ban non-compete agreements? Very, very doubtful. Will the rule do things like we've seen in other states, like in Massachusetts, that says that you can only have non-compete agreements for exempt employees, not non-exempt? Or could it be tied to income levels? Could we see requirements like we see in some states that if the person is going to be bound by a non-compete agreement, that during the period that they're bound, that be considered, quote, garden leave? What's garden leave? It's where I have to pay the person some percentage of their regular wages while they're sitting out or subject to the restrictive covenants. We could see that. Again, it's unlikely that we're going to see a ban altogether, but we are going to see something come down from the FTC, and it will be relatively soon. And we can be sure that there'll be business groups like the Chamber of Commerce and others that will challenge those rules in federal court. So there'll be a lot of uncertainty with respect to non-compete agreements in just about every jurisdiction. Of course, we know, and we have a list of 4 states here, California, North Dakota, Montana, Oklahoma, that have already essentially banned non-compete agreements. But typically non-compete agreements, that's governed by state law. This is a whole new thing that we're looking at with President Biden's executive order, because the federal government is jumping into the game. So with that, I see that our lunchtime 1-hour webinar time has come to an end. I know that we have a number of questions that we were not able to address. Mark, can you get to the next slide, please? One more. If you have additional questions, here's our contact information. Feel free to reach out. I hope that you enjoyed the webinar and that you found it helpful, and I wish everyone a good rest of the day. And thank you to Mark and Hope as well.
Thank you.
Thank you.